This is the web transcription service of the Royal Canadian Military Institute, and this is Eric Morse welcoming you back to our podcast series for spring 2013. On April 17th, the Judge Advocate General of the Canadian Armed Forces addressed an RCMI dinner on the theme of new challenges in Canadian military law. Major General Blaise Cathcart.
Thanks very kindly, Ed. I'm on a roll this week. It's the second speech in a few days, which normally I just get to talk to my own folks who are here tonight, and they have to listen. So I really do appreciate the RCMI making this time. I know you have options for many speakers and talented speakers, so I appreciate giving the time and the slot for myself to talk. Not so much about myself, frankly, but what the JAG as a position is, and what those many of the folks you've met here tonight, my young officers, some not so young, I'm not looking at Rob Holman, that do great work, not only for me, but really on your behalf and on Canada's behalf. So I appreciate that kind introduction, Ed. As I said to some other introducers this week, I'd like to take you all on tour with me, because I need to make me look good, and you have. Thank you very much. As I said, it's an honor to be here today to join a long line of leaders both from inside and outside the Canadian Forces who have addressed the Institute, the RCMI, on matters of import in military and national security matters of the day. My topic for this evening is such a matter of import: contemporary challenges in Canadian military law. And by way of introduction, I want to introduce you to a term that you may not have heard before, and the term is called lawfare. Major General Charlie Dunlop, a former Deputy JAG of the USAF, the United States Air Force, was the first to use this term. He defined it. Actually, Charlie's a good friend of mine, now teaches at Duke Law School in the States. He termed this, defined lawfare as the exploitation of real, perceived, or even orchestrated incidents of law war incidents being employed as an unconventional means of confronting a superior military power. More recently, we military lawyers have come to understand and use the term in a broader sense, one that includes the use of domestic laws and domestic legal mechanisms by a variety of actors to achieve an asymmetric effect. Contemporary commentary on a broad variety of military matters, both in Canada and abroad, and from commentators who are both knowledgeable and frankly unknowledgeable, reflects an increasing focus on the legal aspects of a range of government activities having to do with security and defense. Legality is intertwined with legitimacy. Laws and their application can be very complex, and in the contemporary security environment, there are ever-increasing pressures on governments to address the perceptions with respect to the legalities of their actions. With that lawfare context in mind, I propose to speak to you tonight about three of the issues that are currently occupying a good deal of my time and that of my folks. One from what we call each pillar of military law. We have what we term inside the office of the JAG, three pillars of military law. The first topic will be the concept to push the civilianization of Canada's military justice system. The second issue will be a little more focused in administrative law on the concept of boards of inquiry and what they do and what they cannot do. And finally, the growing discussion of autonomous weapons. To set the stage, however, I would like to take a few minutes to speak about my role as a Judge Advocate General and about the Office of the JAG, who we are, and how we are structured in the areas of law that we practice. I realize obviously many in the room have served and are familiar with the JAG, but over time and space, our role has evolved, obviously in the right direction, from my opinion, but it really is my role as I took over as JAG now 3 years ago, was to do outreach opportunities such as this to help Canadians on the broader scale, but even internationally, folks understand what precisely the JAG and the Office of the JAG does. As JAG, I, by virtue of the National Defence Act, act as legal advisor to the Governor General, the Minister of National Defence, the Department of National Defence, and the Canadian Forces in matters relating to military law. That is a very broad responsibility on two different axes. First, although the Governor-General and the Minister of Defence and others whom I advise at the highest levels of government make up a small number, as you well know, the Department of National Defence encompasses some 28,000 professionals and employees, and the Canadian Forces, which is very distinct, as many in this room know from the Department of National Defence, has close to 68,000 members of the regular force, another 25,000 in part-time reserve force. Second, the scope of military law, which is that law that governs the armed forces in peace and during armed conflict at home and abroad, is itself very broad. Military law encompasses not just the law applicable to military operations, and by that I mean just not the use of weapons or the use of force, but also what might be perceived as more mundane but no less critical items such as contracting and claims. But also the law related to the administration of military members, from recruitment to retirement and everything in between, including pay and benefits, and Canada's separate military system of military justice, a constitutionally recognized system whose purpose is to ensure the maintenance of good order, discipline, and therefore the effectiveness of the Canadian Forces wherever they are. Crucially, my role in respect to military justice is not limited to that of legal advisor. I am also, again by virtue of the National Defence Act, the superintendent of the administration of the military justice system in the Canadian Forces. Those responsibilities were described by the late Chief Justice of the Supreme Court, Justice Antonio Lemaire, as being, quote, similar to those of the Attorney General as historically performed by the JAG under English common law, unquote. To assist me in carrying out my responsibilities, I command the Office of the JAG, which comprises 160 regular force officers, that is to say, as you well know, full-time folks, and about 60 reserve force or part-time members, and around 100 civilian support staff. The office is organized into 4 functional divisions, each headed by a deputy JAG. 3 of those divisions deal with the provision of the advice that I've referred to already, the pillars of military law, being military administrative law, military justice, and operational law. The officers within these divisions are based in Ottawa and provide advice to senior leaders, key officials, and their staffs at National Defence Headquarters. The Deputy JAG for Military Justice also assists me in my superintendent's role, while a Deputy JAG for Operational Law also provides legal advice to the Commander of the Canadian Joint Operations Command, currently Lieutenant General Stu Beer, and to the deployed task force commanders that he commands. This includes deploying my legal officers to provide legal advice to those commanders. Also based in Ottawa is the Deputy JAG for Regional Services. His team is made up of legal officers and support staff located in headquarters, on bases, and in armories across Canada, in the United States, and in Europe. These legal officers are, for lack of a better term, but I think quite apt, jacks of all trades, advising commanders and staffs across the whole spectrum of military law. And many in the room tonight with Commander Suxdorf and her team are really those regional legal advisors here in the Ontario LFCA region. Finally, and also part of my superintendent's function, I provide general supervision to the Director of Military Prosecutions and the Director of Defence Counsel Services, who are responsible to prosecute and defend, respectively, at courts martial. Each of these officers is appointed by the Minister for a fixed term and has the legislative, regulatory, and administrative protections required to exercise their duties and functions in an independent manner. They are assisted by Canadian Forces legal officers who are posted into and out of those organizations as part of their normal career progression. A small group of lawyers, a large client organization with a huge geographic footprint and a broad scope of practice. We call ourselves, quite aptly, low density and high demand. And as you might imagine, the increased operational tempo for the Canadian Forces as a whole means increased legal tempo for our lawyers. At one point during early 2011, for example, we had 17 legal officers deployed, supporting combat operations in Afghanistan, also in the vicinity of Libya, but also mentoring legal officers in the Afghanistan and Democratic Republic of Congo in the development of their own national military justice systems. Allow me then to turn to my three issues that I mentioned before, starting with some thoughts on what can only be characterized as, frankly, a series of attacks on the legitimacy of Canada's separate and constitutionally recognized system of military justice. A system that, in my view, is essential to the maintenance of discipline and therefore essential to the effectiveness of the Canadian forces. Military justice. I have witnessed significant changes amongst Canada and our closest allies over the past 20 years in attempting to balance the requirements to maintain discipline and operational effectiveness while ensuring the accused is accorded all rights prescribed by law. Canada, like many Commonwealth allies, traces the roots of its military justice system back to the British model. Following Confederation, that model continued to be followed almost slavishly up until 1950, when the current Code of Service Discipline was enacted in the National Defence Act. While the British roots are still evident, there have been major reforms to the military justice system since 1950. The most notable were those that followed the enactment of the Canadian Charter of Rights and Freedoms in 1982 and the case called MGen, a decision of the Supreme Court of Canada in 1992, and significant legislative changes made to the National Defence Act in 1998 under Bill C-25. In the case MGen, the court acknowledged that for the purpose of military justice, the purpose of military justice is to allow the armed forces to deal with matters that pertain directly to discipline, efficiency, and the morale of the military. The MGen decision ushered in an era of amendments to the National Defence Act that would be examined in great detail by our allies, as the role of the chain of command in appointing the prosecutor, military judge, and panel members at courts-martial would be eliminated and replaced with provisions to ensure independence and impartiality in accordance with the Canadian Charter. MGen was followed by the tragic events in Somalia, leading to Somali inquiry that examined, amongst other things, the military justice system. It was in this period, during the 1990s, that the military justice system was under great scrutiny. A key actor in the modernization of the Canadian military justice system was the late retired Chief Justice of Canada, Brian Dickson, who was asked by the government in 1997 to chair the Special Advisory Group on Military Justice. Chief Justice Dickson's recommendations led to many changes to Canada's military justice system in 1999 with Bill C-25. These included setting forth the role and responsibilities of the JAG in the National Defence Act, establishing an independent director of military prosecution who prefers charges to be tried by court-martial and has the conduct of all prosecutions at courts-martial. Also allowing a greater number of CF personnel to serve on court-martial panels, and the creation of a court-martial administrator who is now responsible to convene courts-martial. And finally, establishing the Director of Defence Counsel Services with a specified mandate to provide legal services to accused personnel subject to the Code of Service Discipline. Following the coming into force of Bill C-25, there have been two independent reviews of the military justice system, one in 2003 by the late Chief Justice of Canada, as I mentioned, Antonio Lemaire, and another in 2011 by the retired Chief Justice of the Ontario Superior Court of Justice, Patrick Lesage. Both of these eminent jurists made a number of recommendations with a view to enhance the military justice system. Of note is that Chief Justices Dickson, Lemaire, and Lesage all supported the Canadian military justice system as a separate and unique system of justice, vital to maintain the discipline of the Canadian Armed Forces while adhering to the Charter. There has been some recent commentary suggesting that the military justice system, in particular the summary trial system, has not developed in a manner that is consistent with other countries, some of whose legal systems have grown from the same British roots, but many of whose did not. A particular note, as an example, as many of you may be aware, is Michel Drapeau, who writes and comments frequently in the press and in the Law Times, or the Hill Times in particular, attacking particularly the summary trial system. And we've responded primarily through my DJAG for military justice, Colonel Mike Gibson, several times. Many of you may have seen those exchange of articles. We hope not, only to the extent that we think that Michelle's comments are quite inaccurate and actually don't help the advancement of military justice or the enforcement of discipline and effectiveness in the system. But nonetheless, certainly in the Ottawa context, there are those who will listen to such commentary. So part of what I do when I speak is to also highlight the changes, and that there is clearly another view. We like to think a much more accurate and subject matter expert view from the position of the office, from the perspective of the Office of the JAG. Pointing to changes amongst our allies is informative, but responsible military justice reform requires a fulsome comparative analysis that includes understanding the legal rationale behind such developments, including the legal traditions and constitutional structures of the states in question. In terms of the Canadian military justice system, the summary trial system has been extensively examined by the Chief Justices I've mentioned previously, and Patrick Lesage. As recently as 2011, these reviews have reinforced the view that the summary trial system is compliant with the Charter. In fact, Mr. Justice Lesage specifically rejected a submission by Michel Drapeau that the summary trial system was unconstitutional, and Chief Justice Lesage opined, as did Chief Justice Dixon, that it would likely survive a constitutional challenge. As with any justice system, improvements can be made. Over the past decades, judicial decisions have caused the government to amend the National Defence Act from time to time. Further, in response to the Lemaire report recommendations, the government has attempted on 4 occasions to advance legislative making significant changes to the NDA in 2006, 2008, 2010, and with the current bill, C-15, which has been considered by the Standing Committee on National Defence and is currently being debated at third reading in the House of Commons. In terms of contemporary challenges, it is interesting to observe that as JAG, my colleagues around the world are also reconciling the need for military justice, for a military justice system to maintain discipline and operational effectiveness while fully recognizing the accused's legal rights. For instance, in the UK, a series of judgments before the European Court of Human Rights in the 1990s resulted in significant amendments to their military justice system in 1996 and 2006. The UK now has a civilian head of prosecutions with civilian judge advocates who play the role of trier of law, although the verdict and sentence at courts martial is still determined by a panel of military members. In Australia, the military justice system is also undergoing significant changes. Following a lengthy review of their military disciplinary system, the Australian Military Court was created in 2007 to replace traditional courts martial. In 2009, the court was deemed unconstitutional and ceased to exist. This ruling resulted in Australia's retaining their, quote, traditional court-martial system, but the government in Australia has tabled legislation in 2010 and in 2012 that would replace courts-martial with civilian judges. In previous legislation, the Director of Military Prosecutions was created. Thus, any cases would be prosecuted by military members. The legislation creating the new military court of Australia is currently in the parliamentary process. I note that during a study of the bill, various witnesses have testified that because the court would not provide the accused the right to be tried before a jury or a military panel, a constitutional challenge may be in the offing. In the US, the military justice system has also been under scrutiny quite recently. Allegations of sexual assault at an Air Force training base have led to numerous courts-martial. In a separate case, a decision by a convening authority, in that case a 3-star general, to dismiss a sexual assault conviction led to a Senate hearing involving sexual assault in the armed forces. Finally, on April 8th, just recently, the Secretary of Defense, Secretary Hagel, announced he was recommending to Congress to amend certain provision of its Uniform Code of Military Justice, the UCMJ, dealing with the role of the commander in the court-martial system. These would remove from the convening authority the ability to overturn court-martial decisions, except in all but the most minimal cases. Even then, any decision to reverse a conviction would have to be supported in writing by the military convening authority. What is really interesting to note is amongst Canada and our allies, we have all looked to one another in attempting to reconcile the balance between discipline and fairness. While comparative analysis is useful, each country has a distinct legal framework and obligations such as the Charter or the European Convention of Human Rights, as the case may be, that will cause each country to differ in their respective approach somewhat. From the Canadian perspective, as Superintendent of the Administration of Military Justice, I am confident that our system fully complies with the Charter while still serving the disciplinary needs of the chain of command. And again, I spent some time particularly on that comparative piece because, again, someone like Michel Drapeau spends a lot of time making what we consider to be erroneous and rather simplistic comparisons that, well, the UK does it this way or Australia does it this way, Canada does it, so the Canadian military justice system must be wrong. So again, we have to engage constantly to make sure at least the facts are correct. And then if you want a good and honest debate on the law, we're willing to do that. We're not about perfection, we're far from it, but we're open to ideas as long as they're reasonably presented and without the agenda essentially to take down or fully civilianize the military justice system. Turning now to my second issue, military administrative law. As I suggested in my introduction, the practice of military administrative law touches on all members of the Canadian Armed Forces, and as a result is often at play in many circumstances underlying stories receiving media coverage. Let me say a few words about boards of inquiry, BOIs. Canadian Forces Boards of Inquiry are convened under Section 45 of the National Defence Act when the Minister or the CF chain of command needs to be informed on CF matters. That is, those connected with the government, discipline, administration, or functions of the Canadian Forces, or affecting any officer or non-commissioned member. While CF Boards of Inquiry share some characteristics with a public inquiry, for example, they both have the authority to obtain evidence by way of sworn testimony, a Canadian Forces Board of Inquiry differs from a public inquiry in a very significant respect. In evident contrast to a public inquiry, a CF Board of Inquiry is an internal inquiry. In fact, as the federal court has confirmed, when the CBC sought access to the proceedings of the HMCS Chicoutimi Board of Inquiry, which was in the inquiry into the fire aboard the vessel, aboard the submarine, the federal court said clearly that our boards of inquiry are internal inquiries which report to the convening authority on what happened, what can be done to prevent its reoccurrence. It is, in essence, a private investigation. Simply put, a BOI's purpose is to inform the chain of command about a matter in order to take any steps necessary to deal with it. CF boards may not make findings of criminal or civil liability. In fact, the board members come to believe that a service offense, if they come to believe a service offense has been committed, the board must be adjourned while a disciplinary investigation is conducted. The matters which can be investigated by a board include not only those incidents most likely to result in public attention, such as a death or a serious injury to a CF member, but matters such as fires which damage or destroy public or non-public property and significant losses of public funds and security incidents. As I previously mentioned, in investigating such matters, the key concern for the CF is to clarify what happened and identify any lessons that can be learned from those events. In order to ensure that a board's findings represent something more than its own opinion or speculation, they must be based upon evidence gathered by the board. Those findings and recommendations are presented to the commander, who convened the board, and anyone else with the responsibility for implementing recommended changes. Evidently, where the board is examining the death of a CF member, family members may also be keenly interested in the results of the board's work. Families may well be surprised by the amount of time required for a board to carry out its work, particularly if there are also a separate disciplinary investigation going on, and for its findings and recommendations, that is the board's findings and recommendations, to be reviewed and approved by the chain of command. However, this deliberate pace is due to several factors. First, suitable board members must be chosen. In order to ensure their objectivity, they must not have been directly involved in the incident, may not be appointed, that is, a member cannot be appointed if it's a real or perceived conflict of interest exists or may arise. However, it may be helpful if they have a general knowledge of the area being investigated. Second, board members must obtain a general understanding of what occurred by gathering documents and conducting informal interviews. This allows them to identify those from whom sworn testimony will be sought. Once that testimony has been obtained, the board analyzes that all of the evidence, finalizes its conclusions and recommendations, then submits its report to the convening authority. Third, the convening authority must review the board's findings and recommendations to confirm that the board provided all of the required findings and that those findings are based on evidence gathered. This ensures that a board does not draw conclusions merely on the basis of the opinions formed by its members. The convening authority then signals its agreement or disagreement with the findings and indicates whether or not the recommendations will be implemented. A board investigating the death of a CF member may at this point provide a verbal summary of its findings and recommendations to the member's family. However, the board's report may not be released because its completion represents only the first stage of the report's review and approval. Board reports must in many instances then be approved by the Chief of Defence Staff or by an officer within National Defence Headquarters on his behalf. Only after all these steps have been taken and completed can the board report be released, because the CF view of the incident consists of the board's findings and recommendations as well as comments of any others required to review and approve them. While this entire process may require a year or more, the long wait ensures that a family will not be provided with a copy of the report, only to be informed at a later date that the approval authorities don't agree with some aspect of its contents. So it's basically quite a practical approach that the board does its work. If that was the end of it and you disclosed it to families in emotional situations, and then higher authority says, well, we don't agree with those findings or recommendations, obviously the family is going to be even more confused than they initially started out as. The report must usually also have some information removed from it before it's released, because the CF may be prohibited from disclosing certain types of information. For example, personal information except in accordance with the applicable legislation, normally the Privacy Act. Families may also be disappointed to find that the board has not considered some aspects of the CF member's death that the family considers to be key. In view of the authority and purposes set out in the National Defence Act, boards are asked to determine whether a death was attributable to military service by looking only at elements of the member's military history. This obliges the board to focus on those areas where the chain of command is able to effect any necessary change, rather than on personal factors which may also have contributed to the death, and should allow the board to complete its work more quickly. In particular, families who have lost a CF member to suicide are no doubt hopeful that the board, which examines the death, will provide a full explanation for it, identify anyone who played a role in it, hold them accountable, and otherwise help the family to deal with their grief by providing closure. While the board's report may indeed help to clarify the circumstances of that death, it is important to keep in mind that its mandate and the authority arise from and must remain closely tied to CF requirements rather than family or public interests. Your eyes may have glossed over a bit because of the nature of that administrative focus on boards of inquiry, but I felt it's very important, not only for this audience, for others to understand it, because it's those types of inquiries that are extremely emotionally charged and get a lot of attention, again, in the public, and there's a lot of misinformation about how boards of inquiry are supposed to operate. It's very delicate because we have, as you can imagine, the chain of command is extremely sensitive and concerned about, especially in cases of suicide, that the family are informed. And in many cases, this is the only inquiry or investigation that a family would see occurring, other than perhaps a police investigation. But we also have to keep reminding not only the public and families, but our own chain of command, that this is not the purpose of a board of inquiry, as I've outlined, that it may have an effect, a positive effect for families, but it's not designed. And so again, when you get certain critics who say, well, you know, we need access and it has to be a public inquiry, this is why, in the end, that the CF and the government cannot allow it to be because of the way the rules are constructed. And that's not as an excuse, that's actually as a practical tool. The board's inquiries were designed to help the chain of command resolve those types of incidents. I should add, because I didn't say it the first, Ed, and it's up to you, you're controlling it, that any of these issues or others, I'm more prepared at the end of my remarks to take any comments or questions from folks.
I have the question to answer.
Good, okay, just in case, hopefully it'll stir some interest. I appreciate that. Finally, operational law. I now turn to operational law and we'll discuss an issue that is emerging as one of the most significant on the horizon: autonomous weapons and the provision of legal advice in respect of them. So-called autonomous weapons are receiving much coverage in the news, reporting, and in policy, military operational and legal analysis. We refer to them these days as a bête noire of our time. There are many benefits from the idea of weapons autonomy. For example, some argue that machines will ultimately be able to perform better than their human counterparts, with the capacity for gathering more data and processing it faster, all the while performing without passion or fear or hatred or other emotions that could cloud human judgment. To be sure, however, there are also many issues with weapons that are autonomous. Number one, ethical or moral issues. For example, whether the use of autonomous weapons would dehumanize war, lower the costs of war, and thus make them more common, even whether machines have and might have rights as we understand them. Two, technical issues. Example, can we even create an autonomous weapon? How do we look at the idea of artificial intelligence from the bottom up, where we program a machine with a response to every situation, or the top down, where we generate machines that can think for themselves? And as you can imagine, there are a host of legal issues associated with those questions. For example, can an autonomous weapon apply the requirement of distinction, the requirement that only lawful military objectives be targeted in combat to an acceptable degree? What about the concept of proportionality? Engaging in an attack which may be expected to cause collateral damage, which would be excessive in relation to the concrete and direct military advantage anticipated, is unlawful. Can a machine perform the required analysis? Could it ever determine whether the loss of life is, quote, excessive in relation to the military advantage? What about the machine recognition of surrender? We have the rule of law under the law of armed conflict requiring that states ensure that legal advisors are available when necessary to advise military commanders at the appropriate level on the application of international law and in its application of this rule that I would like to discuss for a few minutes. When the idea of autonomy is matched up with the requirement for legal advice, some people get nervous. They might believe autonomy precludes advice of any sort. The worry is that the future is one of self-governing weapons roaming the battlefield, making decisions on their own, far from military lawyers and consideration of any legal advice. Perhaps this, the argument would continue, is a reason why autonomous weapons can never be lawful. You see Arnold Schwarzenegger in Terminator. I do not believe that this fear is justified. Legal advice in respect of autonomous weapons is appropriate, and it is very possible. Let me start by framing the problem. What do we mean by autonomous weapons? While different aspects of weapons can be automated, the problem of legal advice arises most strikingly in respect of two automated functions. One, identifying a target, and two, attacking it. We are less concerned with other types of automation, for example, weapons that can take off or land on their own, navigate independently, or even deliver weapons under remote control. These weapons engage legal concerns for sure, but of a less direct and novel sort. If we define autonomous weapon in light of these functions, we see there is not one idea of an autonomous weapon, but rather a spectrum and different classes of autonomous weapons that can be identified. One, those that automate the targeting decision and have a human make the attack decision, known as autonomous weapons with a human in the loop. Those that automate the targeting decision and attack decision, but allow for a human to supervise terminal effect with the option of canceling an attack, or an autonomous weapon with a human on the loop. So-called fully autonomous weapons that perform their functions independently after being given mission algorithms and released or fired. Given this spectrum, we cannot fall into the trap of describing all autonomous weapons as either lawful or unlawful. This would require an analysis of each weapon on its own, or at the very least, each class of autonomous weapons. As it turns out, the law of armed conflict requires states to consider whether the employment of new weapons would be prohibited by international law. In all autonomous weapons, regardless of where they sit in the autonomous weapons spectrum, would require this sort of legal review before deployment and employment. Similarly, there isn't one answer to whether and how legal advice can work with the use of autonomous weapons. The provision of legal advice will work differently depending on where a particular weapon is in that spectrum of weapons, whether it is a human in or on the loop, or is it truly fully autonomous. One approach we can use is to compare autonomous weapons to existing means and methods of warfare, which states now use for which they receive legal advice. For a weapon with a human in the loop, perhaps this is similar to existing weapons with automation short of engagement decisions. For example, a weapon that is able to track a heat profile, allowing a human operator to confirm the target and engage it, is arguably no different than this type of autonomous weapon. For those with humans on the loop, we already have missiles with supervised terminal effect, where operators can can monitor the impact, the location, and can neutralize the weapon if circumstances change while the weapon is in flight. This leaves fully autonomous weapons, and perhaps here is where we must compare with the fire and forget weapons. These are used in conflict now, from bullets to dumb bombs to long-range missiles. If the circumstances on the ground are not expected to change to an acceptable degree of confidence following the weapon's release, perhaps use of these types of automatic or autonomous weapons is not new from a legal point of view. We are left then with a very narrow class of autonomous weapons which might present new challenges for legal advice. Those autonomous weapons that are fully autonomous and long range or time delayed and used in circumstances where the situation on the ground might well change. These weapons would require new legal advice structures. And given the change that these weapons will be invented, the chances that these weapons will be invented and that they will indeed be deployed, we will need to be, and we are, thinking now about how legal advice will be provided in respect of them. We need to watch the development of these weapons, understand them, and be ready to react in respect of the particular concepts and weapons as they are developed. And again, I highlight that because it's not science fiction. These weapon systems are being developed, mostly obviously in the US. I've seen stuff on YouTube at testing grounds in Carlisle and other places, not so much of weapon systems, but autonomous logistics robots who are just told, take the logistics material from here to there, and the robots figure out their own route and figure out how to get there. So we are not that far away from the ability to weaponize and make fully autonomous weapons, in my opinion. However, what we see already in terms of critics or potential critics out there, we've seen examples recently. Human Rights Watch produced a report in which they basically called for an outright ban, not only on the production, use, but even the production or research and development of such weapon systems. And again, what was challenging and a bit disappointing from our perspective, because frankly Human Rights Watch does, I think, quite a professional job of doing legal analysis on their issues, like detainees, for example, in the past, even though we might disagree with their analysis, but it's usually professional. In this case, it was not, in my opinion. It was a very emotionally based analysis in which they purport to use those principles of collateral damage and distinction and proportionality as a way to say, look, autonomous weapons can never meet these standards, so let's just stop them here. That was piled on recently by folks, Professor Noel Sharkey in the UK, a robotics professor, working with Jody Williams, who won the Nobel Peace Prize for work on anti-personnel mines, now collaborating to seek out a treaty, an international treaty that would again ban not only the use but the very production of such weapon systems. Lots of policy debates for sure, lots of moral and ethical debates for sure, but our challenge from a legal perspective is to make sure that we can say, as I've tried to articulate, that these things are quite capable, in my opinion, of being legally analyzed and then giving governments and government decision makers the choice, perhaps on political, moral, and ethical grounds at that point. So at the end, in conclusion, this is a brief overview of three big issues facing what I do, and more particularly my officers and in the room here. None of them lends itself to an easy solution. Each of them, like so many others, requires that dedicated efforts of my small team of lawyers. I can assure you that each of us is committed to contributing to a disciplined CF and to its mission success in a manner that reflects Canadian values and the rule of law, by providing legal services that are timely, independent, operationally focused, and solution-oriented. once again, I thank you all for making the time. You had other things to do this evening, I know. I hope I presented some interesting thoughts for you, and certainly be welcome to take any comments or questions from you now. Thank you very much.
Here we go. Are there any questions? I have one question for the JAG. On behalf of the RCMI, this is Eric Morse saying thank you for listening to us today. Watch for announcements of future event transcripts, and we hope that you will be able to join us in person for our regular speakers events. Once again, thank you for tuning into our podcasts, and have a wonderful day.